Okay, this is Children in Justice. It is February 25th, 2013, and we are wrapping up learning Module 3. Last week we talked at length about the juvenile justice system, and we discussed how the juvenile justice system is quite different from the adult system of criminal justice. We talked about the different language that they use in the juvenile justice system, and that language is designed in part to emphasize the difference between juvenile justice and criminal justice. The primary difference being the purpose of the juvenile justice system is to be rehabilitative, to help the wayward child get back on the straight and narrow rather than to punish. The purpose of the criminal justice system or the adult system of justice is to punish. So you have words like delinquency and disposition, right? These are words that are different from the criminal courts or the adult courts, and they are reflective in part of the fact that this is a rehabilitative process that is juvenile justice rather than punitive. One area where the juvenile justice system is quite similar to the adult system of justice is what? What did the three cases that we talked about last week essentially say? That when juveniles go to court, what happens?
They have to have basically representation just like an adult would, and they have to be able to call,
Witnesses
and everything like that.
And cross-examine those witnesses. They have a right to counsel. They have the right to remain silent. They have all the constitutional protections that an adult does, including the burden of proof. Tell me what the burden of proof is in a criminal case for adults. What do they call that burden of proof? The state has to prove its case how? Correct, beyond a reasonable doubt. Similarly, the juvenile justice system, if you are accused of an act of delinquency, the prosecutor in the family court has to prove your responsibility beyond a reasonable doubt. And that is an adult concept. So when it comes to the trial, it's nearly the same as the adult court. You have the full range of due process protections that are in our Constitution. However, when it comes to the outcome, when it comes to what happens if you're found to have done what the government says you did, that's where it's different. The focus is not to punish, the focus is to rehabilitate. One aspect of a juvenile proceeding or trial that's quite different from the adult system is that of the fact finder. Who is the fact finder in the juvenile court? The judge. Well stated, Precious. It is the judge. You don't get a jury trial. You don't get a jury trial. The judge will decide guilt or innocence. What about bail? Do juveniles have the same right to bail as adults do in the criminal courts?
No.
I'm shaking my head. No, there's no right to bail for juveniles. And I said last week, and I'll emphasize it again, that seems unfair. We're supposed to treat the juveniles more delicately than the adults, and the adult has a right to get out on bail, but the child doesn't have a right to get out on bail. Well, the presumption is that the child is going to go home. The only reason a child would go to the detention center pending trial is if somehow they're dangerous to themselves or they're an absolute danger to the community. Normally, juveniles go home with their caregiver or caregivers, or they're placed on what we call in Passaic County home detention with some strict rules. They got to stay home, they got to do their homework, they got to check in with a probation officer once a week and those kinds of things. But sometimes when juveniles don't have caregivers who are in a position to keep an eye on them, often that's part of the problem, that their caregivers are not capable of caring for them properly, and the kids get in trouble. If there is not an ability to place a child on juvenile home detention, well, then they'll stay at the detention center. You don't post money and then when you finish your case, you get the money back. There's no bail for juveniles. So you don't get a jury trial, you get a judge trial, and you don't have a right to bail like in the adult system. But when you go through the process of deciding guilt or innocence, that looks nearly exactly the same as the adult process. Sixth Amendment right, Fifth Amendment right, 14th Amendment right to due process. Interestingly, the mega bail hearing in the Pistorius case in South Africa, the Olympic Blade Runner, they called him, because he had prosthesis or prosthetic legs that were looking like blades, and he ran in the Olympics this past summer. His case had a bail hearing, if any of you followed that at all, and it lasted almost 3 days or 4. And it was like a mini trial. I mean, witnesses testified, they were cross-examined. He was able to get in his affidavit statement, which was not cross-examined. I mentioned it a bit last week, and then it continued. That was Monday, Tuesday, Wednesday, Thursday. And the detective who was the primary investigator in the case for the government of South Africa has a pending attempted murder indictment against him. Needless to say, he was pulled from the case and replaced by the top detective in all of South Africa. Now, that arose out of a police conflict where he and others shot at some bus. Nevertheless, he is currently indicted under South African law for attempted murder. But what was interesting was this long bail hearing. Now, I went on a bail hearing after we met last week on that sheriff's officer that I mentioned to you that was accused of having sexual relations with a 13-year-old boy who worked for him at the health food store in Totowa. We made an arrest this past Saturday of a Kennedy high school teacher who was accused of having attempted to pay a boy who went to Kennedy High for sexual relations. We arrested him in the Burger King parking lot Saturday night as he was waiting, fully groomed, hair with Brill cream in it and all, to meet his victim. But the boy never showed. Instead, 9 detectives surrounded his car, and he sits in the Passaic County Jail, and he will have a bail hearing later in the week where I will argue that he deserves a significant bail because he has ties to the Dominican Republic, he has a home in New York State, and these are serious charges, and the quality of the case is pretty good because he contacted the boy through Facebook. And, you know, you can't even delete your Facebook account if you want to. Man, you could go to Facebook headquarters and, destroy all the servers. They'll still have your Facebook account. You know, privacy does not matter to them. Once you're in, you're in. And you can't get out. In any event, his communications with the boy are all preserved on the Facebook servers. So his case is strong, to say the least. That would be a bail hearing, but it's certainly not going to be 4 days or whatever it was in South Africa. And the judge decides guilt or innocence in South Africa in adult cases. One single judge who can appoint 2 helper judges or assistant judges to help her or him decide guilt or innocence in South Africa. South Africa takes a lot of its procedural cues from the system of justice in the Netherlands, the Dutch having first occupied South Africa many, many, many years ago. So the process is quite different than Anglo jurisprudence. We take our criminal process cue from British law and the British common law, and the right to a jury trial goes back a long time in those countries that follow British law. In any event, that's an interesting analogy, the South African prosecution, to what we're talking about today, comparing the criminal justice system for adults with the juvenile justice system. One thing that I didn't emphasize that you're responsible for, and it's part of the last learning module that I want to offer you right now, is about sentencing. I talked to you about the difference between a 4th-degree crime, a 3rd-degree crime, a 2nd-degree crime, and a 1st-degree crime. And as I lower the number, 4, 3, 2, 1, the potential sentence gets higher. So the most serious crime in New Jersey is a 1st-degree crime, 10 to 20 years. A 4th-degree crime, 0 to 18 months. We talked about this in some detail when we discussed Anthony Galloway and whether he was culpable or responsible as a 3rd degree endangering the welfare of a child. Or I should say for endangering the welfare of a child, or whether he was responsible for 4th degree endangering the welfare of a child. They've since been bumped up. When Galloway went to trial, it was 4th degree if you're not a person who has a legal duty or assumed a legal duty, third degree if you had a legal duty or assumed the legal duty. Remember, the whole issue in Galloway was he was dating the mom, wound up killing the child, and the courts were examining whether he had assumed a legal duty for the care of a child. Thus, he would be a third-degree offender rather than a fourth-degree offender. Now, I don't want to revisit Galloway. I just want to point out that the degree of the crime matters. It mattered to Galloway. He went all the way to the Supreme Court to argue that he was culpable of the lesser offense or responsible for the lesser offense. Well, in our system of criminal responsibility, the crime ought to reflect the moral responsibility of the person who did it. So a first-degree crime is always descriptive of an event where a person is more blameworthy than someone who does a fourth-degree crime. And we make these decisions based upon what the average person thinks about an offense. So in my book, animal cruelty ought to be a first-degree offense, because I'm a big fan of animals. I love animals, I love dogs, and I like cats too nowadays. So if I was the person who drafted the laws, I would think that someone who kills or hurts or batters a defenseless little puppy or kitty cat, or even other animals, a hamster, somebody who tortures and hurts an animal like that, to me, is very, very bad and morally blameworthy. And in the Del Russo Book of Laws, I'd probably make that a third or second degree offense rather than a misdemeanor or a petty offense. Although many communities are raising the punishments for animal abuse. And it reflects changing beliefs and the changing culture in our communities, where we realize that it is a bad thing, not simply a bad thing, to hurt a little animal. Okay. And we are also learning more and more that the way we treat our animals is reflective of how we treat other people. Scratch a man who batters his woman or his children, you will find an animal abuser lurking underneath in most cases. Not all cases. But there is a strong and developing correlation in the research between those who batter animals and intimate partner abuse, domestic violence, and child abuse. And that makes sense, right? Because if you can pummel your wife or your child, you're likely a sociopath. And the hallmark of a sociopath is no empathy. You don't understand the pain of others. All that matters is you and how you can advance your personal interests. So if a dog or a woman or a child is in your way, you will hurt them in order to advance your own personal interests. So if you're going to hurt a defenseless animal, okay, that says something about the morality and the level of empathy for that person. In any event, fourth, third, second, first degree. These are the range of offenses in the state of New Jersey and the punishments that are associated with those crimes. Now, after someone is convicted at trial, maybe 2 months later, they'll have a sentencing where the judge will look at the offender, the offense, and then he'll look at the code and see what the maximum sentences are and the minimum sentences are any particular crime. So if it's a first degree, the judge can give out a sentence anywhere between 10 and 20. She can give out a 10-year sentence or an 11 or a 19 or a 16. So in order to pick the number that reflects the appropriate punishment, they have to look at something called the aggravating factors and the mitigating factors. Now, this is kind of fancy legal speak for the bad stuff in his life and about the offense, and the good stuff about his life and the offense. The bad stuff is the aggravating factors. The good stuff is the mitigating factors. So, for example, an aggravating factor would be the person who's up for sentencing, standing before the court, has a prior criminal record. They've committed other offenses. So if you're going between 10 and 20, the judge says, well, this is a person who has a prior criminal history. Let's look at what that is. If it's a pot charge from when they were in college, or they punched someone in the nose 30 years ago, that's not going to have a lot of impact on the judge's final decision. But if it's a series of offenses, or one or two offenses that are really, really severe and significant, well then that might go, instead of 10, maybe 11, 12, 13. The sentence is going to be pushed up the more bad stuff or aggravating stuff. That's just one example. The crime itself. Lawyers often say in the courtroom, well, Judge, there are robberies and there are robberies. A robbery is when you take something from another person by force or coercion. Okay? Many people, when we select them for juries, we ask whether they've ever been the victim of a crime, and they will say, my house got robbed. Or I was at Garden State Plaza and I came back and someone robbed my Christmas gifts from my car. Well, technically speaking, under the law, that wasn't a robbery at all. That's called a burglary. When you go into something, whether it be a car or a boat or a house, and you take something that doesn't belong to you to keep, that's a burglary. A robbery is when somebody uses a gun or a knife or a threat, force, right? And they take your stuff using force, okay, or coercion. So why am I bringing that up? Because we're looking at 10 to 20, right? There are robberies and there are robberies. You may have a robber, right? You may have a robber who's got a prior criminal record, and this robbery, he pistol whipped the person until they bled from the nose, and then he shot them. And then he took their stuff. The person survived, but that's one kind of robbery. Another kind of robbery could be, and we see this sometimes from retail establishments and the like, somebody grabs or takes a pretty dress from Macy's, and they're about to leave, and a security guard goes, hey, stop right there. And they push the security guard, and they run with the dress. They try to get in their car. Maybe they get away, maybe they don't get away. Well, that would be a robbery. Now, you might say, well, they took the dress, but they didn't use force to take the dress. They kind of used force on the way out. Well, robbery is defined as using force to get the thing or to escape after you got something. That's a robbery too. So it could be significant as turning around and shooting at the guard, or just bumping into the guard on the way out. So the person who bumps into the guard on the way out, stealing a $100 dress, would be guilty of a robbery. Same statute as the person who pistol whips someone, shoots them in the belly, and takes their money. So when we look at sentencing, we look at the crime, robbery, and we look at the nature and circumstances of that robbery, and then the numbers go up or down. So the person who bumped into the guard on the way out to take the dress, their lawyer might argue, Judge, this was a robbery, but barely a robbery. And the nature of the offense, what happened here, is not as significant as some of the robberies that Your Honor sentences people on week after week in these courtrooms. So you look at the person, and you look at the offense. We can change it to aggravated sexual assault. Or how about criminal sexual contact? Criminal sexual contact could be touching another person on their chest, on their breasts, private parts, without their permission. That would be criminal sexual contact. It can also be taking your hand and putting it in someone's pants underneath their underwear and touching them on their vagina. Not in their vagina, but on their vagina. Far more intrusive, right? It's still a criminal sexual contact. But when the judge is sentencing two people, one who fondled someone over the clothes, over the blouse, over the bra, in the Burger King, and somebody who puts their hand into the clothing and underneath the undergarments and on the flesh of another person without their permission. Both criminal sexual contacts, obviously one's more intrusive than the other. So you look at the person, and then you look at the crime, and you say, all right, what kind of criminal sexual contact was this? Was it a bad one or not so bad one? And then the judge adjusts the numbers from criminal sexual contact would be 0 to 18 months would be the exposure for a person who's accused of that. Some of the other things that matter in sentencing. I said prior criminal history, whether it was a particularly serious or egregious type of offense, whether they they knew what they were doing, but they were unsure of what was happening. They might have a mental health defense that doesn't demonstrate that they were mentally ill and didn't understand completely what was going on, but they might have had some mental health issues in the past, or they might have an excuse which is not a defense. You know, this guy Pistorius, to talk about that again, he claims that he thought there was some burglar in his house. Well, forgetting about that, he shot them many, many times without calling out and all that stuff. He thought there was a burglar in the house. You know, that's quite different than somebody who shoots somebody to get insurance proceeds, right? I mean, he might have a defense. It's not a complete defense. It doesn't get you off. He might say, Judge, this is, you know, I did this thinking it was a burglar, so when you give me 10 to 20, you should give me a lower sentence because I made a bad mistake here. I made a colossal error in judgment, but it was not something that I really thought about. It was not something that was premeditated. So the judge looks at a lot of these different aggravated and mitigating factors to try to decide what the right sentence is. And then the judge sentences them. Some crimes have what's called a mandatory minimum. Can someone tell me what a mandatory minimum sentence means?
That you have to do the minimum.
Go ahead, what do you think?
Has to do with a certain amount of time mandated by the court. That's the minimum amount of time that they will serve.
Correct. You have to do a minimum amount of time before you are eligible for parole or for release. And those kinds of sentences are very controversial. They're very popular with politicians because it's a way to get tough on crime, right? But they take away discretion, right? The judge can't size up and say, well, this kid, you know, possessed drugs with the intent to distribute, but he's not as dangerous as a person who was running a drug sale mill in his apartment, right? So mandatory minimums are sentencing options in every state in America, including New Jersey, in guns, drugs, second-time sex crimes, and a variety of other crimes have mandatory minimums attached. Or repeat offenders. California popularized something called the 3 strikes law. 3 felonies and you go to life in prison. I watched a movie with my son the other day about mandatory minimums. Not good. Snitch. It was with The Rock was in it, and the guy who used to be a wrestler. And it was all about his son got accused of a drug offense that he was guilty for, but he really didn't want to be part of the drug sale, but he was a victim of mandatory minimum sentences. So The Rock hatches this whole plot to get him out of jail. In a good way. He became a supreme snitch because his son had no one to snitch on because he really wasn't a drug dealer. He didn't know anybody in the drug, in the drug trade in his community. Now, let me just check out one other thing here. Well, I don't know where probation and parole is. It might have been in Learning Module 2, or it might be upcoming, but let me offer you this. It was in Learning Module 2? Thank you, Pamela. This is what I want you to understand, and it's rather simple. When somebody is sentenced for a crime, they don't always go to jail. Sometimes they're placed on probation. Probation. And you get probation instead of jail. Instead of jail. Or in lieu of jail, which means instead of jail. So not everybody who commits a crime in New Jersey or throughout the country goes to jail. Sometimes they're placed on probation. Probation is a form of community supervision. So they stay out of jail, and they are required to do certain things, and that would include weekly, bi-weekly, monthly, periodic meetings with their probation officer. And it may include conditions, just like we talked about bail conditions. Stay out of high drug areas. You're not allowed to be on the internet. You have to give urine or blood samples upon request or periodically. Okay? Did you have a...
Curfews and juvenile school is, most of 10 schools big.
That's right. Within the juvenile system, they have their own kinds of probation conditions that are relevant to children, including curfews and attend school and those kinds of things. So in lieu of jail, you can be placed on probation and have a period of supervision. And if you violate probation, if you use drugs again, or you go on the internet when you're not supposed to, or you keep breaking curfew, or you're truant over and over again, you can be violated. And then the government, whether it be the prosecutor in the family court or the criminal court, doesn't have to prove the original crime. If it was a sexual assault or criminal sexual contact, you already pled guilty to that. That's why you're on supervision. The only thing the government has to prove is you broke curfew, or you used drugs again, or you were on the internet again. So a violation of probation hearing involves the government proving that you broke one of the conditions. And then the penalty is any sentence you could have received for the original charge. So if it was a criminal sexual contact, you are now sentenced to jail for somewhere between 0 and 18 months. And 0 is out of the question because that would be probation. So you may get 6 or 12 or 18 months. If it's a third degree, anywhere between 3 and 5 years. 3, 4, or 5 years in jail. Parole is different from probation. They are similar in the fact that they both involve community supervision. But one is instead of jail, the other one is when you get out of jail. When you get out of jail. When you get out of jail, you're placed on a period of supervision with very similar conditions. Any reasonable condition can be attached to parole. Any reasonable condition can be attached to probation. You're going to see the same kinds of conditions, but if you had a 10-year sentence and you were paroled after 3.5 years, right, it's a period of transition. So then you maybe go to a halfway house, and then you have total freedom other than parole. And then you meet with a parole officer periodically, and you follow these rules. If you violate parole, you don't go back before the sentencing judge, you go before an administrative body called the parole board. And again, the only issue is, did you violate parole? Were you on the internet? Did you use drugs again? Did you get involved in a new offense? And then you go back to jail for the same sentence. You got out 3.5 years on a 10-year sentence. They put you back into jail. The next day you have 3.5 years and 1 day. So you continue the original sentence until you are released eventually. Maybe you're paroled again, or you serve your full and maximum sentence. No one, even in states that have abolished parole, like New Jersey for some offenses, no one serves the entire number of the sentence. No one does 10 years. And the reason is because when you go to prison, for every day that you don't create any problems, for every day you have what's called good time. Now, if I heard once, I heard 1,000,000 times, defendants say, "Judge, I got a lot of good time." Well, that's a term of art in the criminal justice system. That means he was good in jail, and he got credit for being good. So for every day you're good, you get 1 good time credit at the back end. So if you have a 10-year sentence and day 1 you're a good boy all day, you get 1 day off the back end. So now your sentence is 9 years and 364 days. For 7 days, good time, you get 7 days off the back end. So now your sentence decreases, the top number decreases for the good time. So you get 7 days off, right? 365 minus 7 is 350, whatever, 8. And more good time you get, the more time comes off your back end. So eventually there's a ceiling. And that's statutory, okay? Now, there are other ways to earn good time. You can work at the prison library, or you could work in the janitorial section of the cafeteria, or you can help other prisoners do legal research, or you can do stuff that earns good time credits apart from the day-for-day thing. The day-for-day thing is you're a good person all day, you get a free one at the end. 2 days, another one. The third day, another one. Then you can earn credits, right? That's your form of payment. You actually get paid a nominal amount, not much at all. You do get some money. But more important than money to any person in the prison system is time off your sentence. So by working at the prison library, you may get 30 good time credits or whatever it's worth. Every system, every jail has a system of accounting for good time credits and these kinds of things. Somebody would say something?
I got a question.
Yes.
So say you have all this good time built up, but then you have one bad day. That doesn't knock off any of your good time.
No, but there's a formula for taking off some good time. It doesn't knock off all the good time, but I don't know a lot about how the system works day to day, but certainly it impacts. You're going to lose some time here. There's it's merits and demerits. It's the kinds of things you do with little kids, You want to create an incentive for good behavior and a disincentive for bad behavior. You're treated like a child, and that's what prison is like.
Most of them are like a point system, just like our kids having group homes and stuff, where they have a chart, and there's things you commit inside if they're not crimes, and any murder charges. There's literally like a point chart, so. And it's pretty much set in stone. They can appeal it and negotiate it.
Now, you can't abolish parole completely, right? You can't say nobody gets parole, you're going to do the full sentence. Let's get rid of parole. It undermines the public's confidence in the criminal justice system. Well, it does to some extent. If there was no system of parole, what would be the problem in our prisons? Let's say you opened your own prison. People would have no incentive to be good. It would be chaos, You're in line to get some mashed potatoes and a hot dog, man. You hit somebody in the head with a thing. You need an incentive for good behavior. You need an incentive for good behavior. And you also need a transitional period. You can't let a guy spend, 12 years in jail and then just say, see you later, and you walk out and the world's changed. You don't have any skills. You don't have any connections and contacts. You need help transitioning. And it's a good thing, parole, if it's done right. It's a good thing. It's an important thing. It's a necessary thing. It's a necessary thing. Any questions about what we just talked about? All right, let me introduce you to the concept of Megan's Laws, because your next learning project is about Megan's Laws, okay? And you have to watch the video, and it's in there in Learning Project 2, maybe even twice. Okay, because it can be a little confusing if you're not paying attention. And the instructions for how to do this are right here. Read them twice if you have to. You have to read instructions. This is the scale. I'm going to open it up. And we'll take a look at it on the big board. Now, let me say this about Megan's Laws. As many of you know, in the early 1990s, a man named Jesse Mendequaz got out of the state prison system. He was sentenced to the Adult Diagnostic and Treatment Center at Avenel. I mentioned that before. And he served his term, and when he got out, he looked for a place to live. And in Hamilton Township, he rented a private home with 2 other dudes. You know where those dudes came from? The Adult Diagnostic and Treatment Center. So you had these 3 sex offenders living on the block where Megan Kanka lived with her family. And Megan was a little 8-year-old girl, and she went by the house, and sadly and tragically, she was murdered, brutally murdered and raped by this man, and tossed in a garbage bag in a trash compactor. They found her body. Mendequaz was easily captured, later prosecuted. Maureen Kanka, Megan's mother, felt strongly that if the community knew that these sex offenders were on the block, her daughter would still be alive. And she felt that it was important that when sex offenders, who research suggests are recidivistic, they do these crimes over and over again. It's not that clear cut, but that's the perception. And there is a certain amount of recidivism for certain sex offenses that's beyond normal recidivism or repeat offenses. She felt that when these kind of guys and gals are released in our community, recognizing that the criminal justice system can't keep them in jail forever, we can't execute them, they have a right to go home and get out. But she argued, as many did with her, and during that time period, well, if the system is done with them, they may have a right to live peacefully, but we got a right to know if they live on our block, if they live in our community. We believe that there ought to be a system of public notification, and that's what Megan's Law was all about notifying the community when a sex offender is in the neighborhood. That's a simplification of it, but it's pretty close to what it was all about. Now, having said that, the Supreme Court of New Jersey reviewed the Megan's Law statute, which was among the first in the nation, but not the first. They already had a similar statute in Washington State in 1990. This was 1994, October 31st, 94. Megan's Law was passed. We modeled much of our statute on the Washington State statute. In any event, when the New Jersey Supreme Court got a hold of it, and the Third Circuit Court of Appeals in the federal courts, they modified the law a little bit. And in part, they said, listen, you cannot notify everybody all the time about every sex offender. Notification has to be related to risk. So if a guy's a sex offender and he gets out and he's a real low risk, we're not going to go knocking on doors. We're not going to drop leaflets from the sky. We're not going to put flyers on telephone poles, okay? We're not going to do that. We have to balance the sex offender's right to privacy, whether you believe in it or not, he's got a right to privacy, with the public's right to know where they live. And much of that balancing is based upon their level of risk. So somebody who is a sex offender who's a low risk to reoffend, maybe it was a single incident with a statutory offense where it was a consensual offense with a 22-year-old and a 15-year-old and there was no force involved. Nobody's saying it's a good thing. It's still a crime. In fact, he went to jail. But when he gets out of jail, is the general public at risk? Is this a predator? Is this the kind of person like Jesse Temendequas, who's a stone-cold sociopath and murderer? Okay? Do we treat the statutory offender, the 22-year-old who had consensual sex with a 15-year-old, the same way when it comes to Megan's Law as we treat the sociopathic Jesse Temendequas? The answer was no. Notification depends upon risk, relative risk. And they gave us this scale. The scale is used to determine what their risk is. Now, the risk levels are broken down into 3 risk levels. You need to remember this. Tier, T like Tom, I-E-R. Tier 1, that's a low-risk offender. Tier 1, everybody who commits a sex offense that's covered under Megan's Law that gets out of jail is a Tier 1 by default. Then the prosecutors look at your background and they decide whether you're a Tier 2 or a Tier 3. Tier 1 is low risk. Tier 2 is moderate risk. Tier 3 is high risk. 1, low risk. 2, medium risk or moderate risk. 3, high risk. So every sex offender who gets out of jail or who is placed on probation, you have to apply this scale. And the scale looks at factors that have been determined to impact someone's risk of reoffense. And if you watch the video, which you must, that's among your obligations in this learning project, you will see how to apply this scale. If you have any questions, post them to the Cyber Cafe. This way I can answer it and then maybe other students will look at it having had the same question, and I'll only have to answer it once. But going down quickly, you look at the crime that they got out of jail on and any other crimes, and you see what the degree of force was. And when you do your assignments, you'll see how we define that. No physical force to commit the sex crime, minor physical force to commit the sex crime, or did they use a weapon and use lots of violence to commit the sex crime? And each one of these boxes has a number to the top here. See where I'm hovering here? 0, 1, 3. But it gets a little bit more mathematic than that. You take the 0 or the 1 and the 3 and you multiply it by this number times 5. There's the times 5. So let's say the person used minor force and you give him a 1 there, because he gets a 1 because the 1 is for moderate force right up here. You multiply the 5 times the 1 and their total 5. Right? Now, some of these other ones, like how many victims they had in their career, not just this offense that they got out of jail on, their whole life, and you'll have all the reports. Let's say there were 3 or more victims. Okay, 3 or more victims, 3 is the number, right? What's the power? This one had times 5, times 3. So I'm going to give this guy in number 5 category the 3, and I'm going to multiply it times the 3, and in the right-hand field here, they'll get a 9. And at the end, you add them all up, and you get a total. Let's say the total is 65. 65 falls in the moderate range, so they're a Tier 2 offender. Okay? Now, this learning project is due March 3rd, right? So that is going to be before we meet again, isn't it? Okay. So I have to leave now. I want you to post in the Cyber Cafe if you have any questions about it. Rest assured that the video is long and detailed, and it's me talking as I would if I was standing here. So I go through, just like I did now, I go through each one of those. I go through each one of those in great detail as if we were in class.